Tēnā tātou katoa. I'm going to talk a little bit about the Indigenous foundation of New Zealand's constitution. But first, just introduce myself. You've got an image on the slide here of the Waitangi River, and that's where my whakapapa comes from. So if I was to introduce myself, I would say, ko whakapuna ke te maunga, ko te wairo hōpupu ho nengenenga mātangi rau te awa, ko Ngāti Kahununu te iwi, ko ngai te apatu te hapu, ko taki timu te marae, ko Carwyn tōku ingoa. And I give that background to partly just to introduce myself and identifying my mountain, my river, my iwi, hapu, and my marae, but also so you know where it is I'm coming from. And because also that whakapapa and the authority that's grounded in the land are important aspects of what I'm going to be talking about. So there are really two strands to my work, and the first is Indigenous law, particularly Tikanga Māori. The second is constitutional law, specifically thinking about the role of Te Tiriti or Waitangi in the New Zealand Constitution. And what I'd like to address today is really just to prompt some thinking about what it means to understand our Indigenous constitutional foundations. Now, I mentioned that whakapapa is central to this, and in particular how understanding can be shaped by a whakapapa lens. So first, everything has a whakapapa, nothing stands in isolation. It tells us that we should seek to understand the whakapapa of those key ideas in Te Tiriti, tino rangatiratanga and kāwanatanga, those two spheres of authority and the relationship between them. But the whakapapa lens doesn't just help us to see where these constitutional concepts have come from, but the second way this lens is important is that understanding where those concepts have come from helps us to understand their present and future relationships and their appropriate points of connection, how to properly give effect to the constitutional relationship between the Crown and iwi and hapu. Now, if we could just go to the next slide, please. My colleague Ani Mikaere describes tikanga as the first law of Aotearoa. And there's a statement in the Peter Ellis case, which was heard by the Supreme Court, and evidence about tikanga was given there, which said that tikanga is the law that grew from and is very much embedded in our whenua, our land. Tikanga regulated the lives of Māori when the first European settlers arrived in Aotearoa, New Zealand, and it has never ceased to do so. So Māori legal traditions are sourced in tikanga, and tikanga describes the right or correct way of doing things within Māori society. It's a system comprised of practice, principles, process, procedures, traditional knowledge. It encompasses Māori law, but also includes ritual, custom, and spiritual and socio-political dimensions that go well beyond what we might think of just as a strictly narrow legal domain. But there are a number of important implications, I think, that flow from understanding tikanga as the first law of Aotearoa that are important for our understanding of the theory, practice, teaching and learning of law in Aotearoa. And the one aspect that I want to focus on today is to consider the implications for our constitutional foundations. Next slide, please. It's well recognised that Te Tiriti or Waitangi is a foundational element of the New Zealand Constitution. Te Tiriti sets up a framework in which public power is to be shared across two spheres of influence and authority. It guarantees the continuing authority of Māori as tino rangatira and creates a space for the Crown to exercise authority over its own subjects here, an authority which is described as kāwanatanga. And to understand Te Tiriti and the nature of tino rangatiratanga and kāwanatanga, it's important to see this in the context also of the 1835 Declaration of Independence, He Whakaputanga, which was signed by chiefs primarily from the north just 5 years before Te Tiriti. And it provides a statement by the rangatira that New Zealand is an independent state. The term that's used is he whenua rangatira, and that the rangatira, the chiefs, are the only ones who exercise governmental authority here. Now, Te Tiriti, of course, opens up space for the Crown to exercise its own sphere of authority as well. So, He Whakaputanga is the foundation for the understanding of the authority of the rangatira, and also the foundation for understanding the nature of New Zealand as an independent nation state, He whenua rangatira. And I think this is an incredibly important phrase, and it partly speaks to some of the difference in language that we see used between the Declaration of Independence, He Whakaputanga, and Te Tiriti or Waitangi, as I say, just 5 years later. But this concept of he whenua rangatira, here we can see the idea of an independent nation state is reflected by these two profoundly, deeply Indigenous, deeply Maori concepts: whenua, land, rangatira, chief or leader. And so that's the way that that idea of an independent state is articulated. And so I think it makes sense to understand Te Tiriti as part of that whakapapa and within a Maori constitutional framework. And what is more, I think the concept of whenua rangatira is really powerful in the sense that it can help us to think about how we can strengthen our constitution and our constitutional relationships. Next slide, please. And understanding this constitutional whakapapa, recognising tikanga as the first law of Aotearoa, allows us to move the discussion about Te Tiriti beyond a debate about meaning that takes place entirely within the state's constitutional traditions, and instead frames the treaty's meaning by the parameters of a Māori constitutional tradition. So we have these two important ideas in Te Tiriti, tino rangatiratanga and kāwanatanga. They stem from Te Tiriti or Waitangi, but they're actually underpinned by he whakaputanga o te rangatiratanga o New Tirani, the Declaration of Independence of 1835, and that important fundamental concept, he whenua rangatira. And so the overarching point, I think, that can be drawn when you start to examine Te Tiriti or Waitangi as part of the Māori constitutional tradition is that the treaty should be seen as one component of an ongoing and developing relationship between distinct constitutional traditions. And that ongoing relationship recognises ongoing diversity, and it directs us to focus on mechanisms not of assimilation, but mechanisms for interaction and connection between communities with distinctive constitutional traditions. So this doesn't require one party being subsumed by the other or the legal traditions of one party smothering the others. Rather, on this view, Te Tiriti provides a framework for contemplating how we might give best effect to these two spheres of authority to strengthen our constitutional foundations within he whenua rangatira, an independent state. And so to make good on that vision that sees Aotearoa New Zealand as he whenua rangatira. Tēnā tātou katoa.